Hello. Resource person join பண்ணிட்டாங்களா? Resource person. Hello.
Sir, no, sir. I think Jaypriya will take follow-up, sir.
Sir, phone பண்ணுங்க.
Sir, சொல்லுங்க sir.
ஜாயின் பண்ணிட்டார் போல இருக்க.
Name VS Kumar நிக்கல sir.
ஜாயின் பண்ணிட்டார் சார்.
Okay sir. Start பண்ணலாமா sir?
ஸ்டார்ட் பண்ணுங்க சார்.
Good morning everyone. I am very happy to welcome each and every one of you gathered here to today's virtual workshop on industrial relations practice in Indian scenario, held on 25th and 26th June 2021. Thank you for everyone. Now I am glad to invite our professor and head Dr. R. Mangaleshwaran, Department of Social Work, Bhadasa University, Tiruchirappalli, to deliver welcome address. Thank you, sir.
Okay, yeah. Audible?
Yes, audible, sir.
Yes, sir. Yeah. So good morning to all of you. So very warm good morning to all of you. The respected speaker of the day, Mr. Vijaya Kumar and Anand Sivakumar, the co-director of this workshop on the industrial relations practices in Indian scenario, Dr. Selvamani, the organizers, the coordinators of this program, the student coordinators and HR students, research scholars, my dear colleagues, the other speakers like Dr. Ponmolian, and my dear participants, a warm good morning to all of you, and very happy indeed to welcome you all for this 101st webinar of our university. The Department of Social Work is conducting this program, and indeed it's really gives me an immense pleasure in welcoming the today's speaker, eminent speaker of the morning session, Mr. M. Vijaya Kumar, Head Human Resources, ITC of Coimbatore Division, and who will be addressing us on the Industrial Relations Code 2020 and its implication in industries. So on behalf of the Department of Social Work, I extend a warm welcome to you, sir, and I also thank you for accepting our invitation and trying to address all of us on this occasion of this 101st workshop of our Department of Social Work. Thank you very much for joining, and also happy in welcoming the co-director of this program, I think Dr. Selvamani, right? So Selvamani, who has taken a lot of efforts in organizing this program, It's a great pleasure in welcoming Dr. R. Selvamani, the co-workshop director of this program. And I also indeed happy in welcoming all the speakers for this 2 days workshop on the industrial relations in the practices in the Indian scenario. Mr. S. Anand Sivakumar, the Chief Manager, HR of NLC Neyveli, Mr. K. Sadish Kumar, from Deputy Chief Manager NLC India. Then Mr. A. Johnson Anthony Leo, General Manager, Southern Unit of Ramco Cements Limited, and the illustrious alumni of our department, Dr. Podmolian Chinnasamy, the DGM Human Resources from the Varnar Beverages of Pepsi Chennai. So I extend a warm welcome to all the resource persons who will be enlightening us on the various facets of the industrial relations for the today and tomorrow. And I'm also indeed happy and also congratulate the students belonging to the HR specialization, and especially the 7 students, Mr. Balaji, Miss Dharani, Miss Jaypriya, Miss Lakshmi Sri, Mr. Puhal, Miss Shanshia, and Miss Shalini, who has been behind the screen in organizing this great event. Right, so they have been tirelessly working for more than 2 weeks for this conducting of this program. Indeed, we have a good number of registration as usual. The Department of Social Work also has its own significant in mustering more participants from the different parts of India and also different parts of the world also. And I'm very happy in welcoming all the participants who have joined through this Zoom platform as well as through YouTube channel also. And we have a very good number of participants from UAE, Zimbabwe, Philippines, and there is a representation from almost 28 states, right? So that's a good sign, I would say that. And we had received more than 1,000 registration, and of course people will be joining. Now we have around 100 participants have joined through this Zoom platform, and we have around 464 students have registered, and 137 research scholars and 343 faculty members have registered for this program, and 83 professionals and others also have joined. Other people from the other specialization also have joined this event, right? So my wishes to all the participants for a happy learning experiences for the next 2 days. With these few words, I also once again I welcome the resource persons of the day and the coordinators, the co-directors, and the participant for this virtual program, the 2 days program on the industrial relations practices in Indian scenario. Right, so this is a very vital topic, and very, that industrial relations climate is keep on changing from day by day. So when we were a student and when we were in the early 90s, right? So the situation of IR has been a different scenario. And when it comes to the present conditions due to the impact of the liberalization, globalization, and privatization, and also now we are in the digital era, right? So the things are changing, right? Things are being changed, and more people have gone beyond awareness level on the aspects related to IR. And of course, there are certain issues which is need to be addressed on this industrial relations scenario. And as a student who have been participating in this workshop, and they should really understand how difficulties the HR professionals or the industrial relations professionals are mastering in bringing about a balance between the workforce and the management. So there lies the significant role of an IR executives and our HR manager in terms of IR practices, right? So I hope that these 2 days will enlighten and enrich you with a shower of knowledges on the industrial relations practices on the Indian scenario, and especially the experts will be addressing on the current scenario, and that's a welcome note from my side. And thank you, dear participant, for making us with us today, for taking up more steps towards attending this program. So with these few words, thank you very much.
Thank you, sir. Now let's invite our honorable guest, Mr. M. Vijaya Kumar, Senior Human Resource Business Partner, who is proficiency in the field of HR and IR with 21 years of rich experience, currently working in ITC PSPD Division Unit, Coimbatore. In role as head human relations, his professional experience gained in earlier association are Dalmia Cement Bharat Limited, Hindustan National Glass and Industries, and Unilever Limited, Pondicherry. Let's invite him to give a massive speech. Sir, the stage is yours. Hello, sir.
Good morning, everyone. Good morning, everyone. I am audible to everyone.
Yes, sir.
Yes, sir.
Yeah. Thank you so much for the detailed brief introduction by our professor and the team from Bharadas University. It is an immense pleasure that our professor already given the very brief about this session. And before that, என்னுடைய அன்னை தமிழையும் எம்பெருமான் திருவள்ளுவனையும் சிறப்புமிக்க திருச்சி மாநகரத்தையும் வணங்கி இந்த செஷன், IR code, the subject, which is very vital for this current scenario. Last 3-4 days now, I'm having very close connect with one of the student from university, and she is very much active that wanted to have a session on that. She approached me, and there is a protocol for me to get a formal approval on that. So I escalated to my management, ITC, and thank to my senior team also to give the permission to represent on behalf of ITC to take this one of the important code of labor reforms. I think prior to get into that directly get into that subject, just wanted to say hello to everyone and hope that everyone is safe, as the situation is not so conducive as earlier 2 years before what happened, the COVID situation.
Hello, sir.
So lot of.
Hello, sir.
Sorry.
So sorry for interruption. If you possibly kindly turn on your video, sir. Your video is off.
Oh, sorry. Oh, sorry. Sorry.
Now
visible. It has to be operated from your side. I believe.
No.
Sorry.
Now visible.
Now
sir.
I am visible. Now everybody.
Yes, sir.
Thank you. So now the situation is now that not favoring to us to lead the normal life because of the COVID situation, and usual ordinary people are suffering a lot, and even the people are working in the industry is very, very much difficult to do the coordinating the people as well as the ensuring the business goes to the right path in a profitable way or the normal course of operation. There's a great challenge. Anyway, now we learned a lot of things. Learning is in every walk of life. So the learning from this pandemic situation also one of the great learning for us, which is also one of the things why I'm stressing on this COVID learning means the relationship, whatever the relationships is mentioning in the Industrial Relation Code, IR Code 2020, the relationship is very, very important wherever it go. So there may be a lot of definition is there. What is industrial relations? What is a social relation? What is a personal relation? Many relations are there, but there is a defined way of establishing the relations in industrial relations context is the most important, because it is involving both the party of management as well as the union workmen, all those concerned, and inviting the officials from the government also. So wherever the people is closely associated with the operation of the business and ensuring the smooth relationship for the day-to-day affairs of the organization, is setting the smooth and perfect relationship for the industry that is expected by each and every industrialist. And now various factors now influencing how the relationship should be sustained, how to the relationship is to be taken for the next level in terms of the approach, individual approach, as well as some of the mechanism and some of the directives. All those things are there. So for mentioning all those things, most important typical structure is the government body which regulates the business operation in day-to-day, and which also give the perfect guidelines what to do, what not should not do, what is the responsibility of the management and what is the responsibility of the workmen concerned and others. So it is clearly establishing that so that everyone should do their own responsibility, deliver the responsibility in an established way as per the guidelines by the government. So for various enactments, so various labor law was there. So around 29 labor laws are there, and industry has to follow the various rules and regulation laid over there. So it is a mandate by the organization to ensure 100% the compliance part by fulfilling the labor laws, regulations, rules, and compliance part. So that is most important prime responsibility of the organization. At the same time, it is not only the responsibility by the organization, but it is also vested with the employees part, who are also there regulating certain laws, regulation. So going forward, there are a lot of difficulties to administrating these kind of various enactment, various laws, various definitions, and various aspects, perception, interpretations. All those things are there. So which is certainly it's give a lot of ambiguity. For example, a wage in a Payment of Wages Act, the definition, which is also not is retained in the definition as per the minimum wage or in the bonus, whichever. So different connotations, it is keep on changing. So it is very difficult to fulfill and leading to a lot of ambiguity. This is one of the great challenges where the central government now coming to the picture, and now they are replacing around 29 legislation, existing labor
Hello, sir.
laws, and put into 4.
Sir, you have any PPTs? I think you will not share the screen if you have any
Yeah,
PPT.
PPT is there. Just this is for just I'm preliminary. I'm making it. I will.
Then you
I'll
share the
PPT
screen,
also.
sir.
Okay.
No, now you share in Zoom. You have access to
So this
share
is the
screen.
context setting. Right now I'm going PPT. I will share 1 minute. Just a minute. I will share the PPT.
If you're not able to share, sir, kindly send me, sir. I will share you.
1 minute. 1 minute. Are you able to share? Seeing now?
It's visible, sir.
Visible, right?
Yes, sir. You just make on
Before getting to
the
the
slideshow,
PPT,
sir. Yes, sir.
is
Perfect.
it okay now?
Yes, sir. Perfect.
Yeah. Now, before getting to the subject, just I wanted to setting the context, how the IR code evolutions and what is the impact and all. That's before, I just wanted to briefing about it. So that the 29 labor laws, which is so far prevailing, before to coming to the picture and the labor code. So now they are bucketing into 4 codes, 4 labor laws, sorry, 4 codes, which is now is simplified in the format. So one of the code is Industrial Relation Code 2020. That is one of the code. The major challenges in labor reforms is facilitate the employment growth while protecting workers' right. That's one of the important aspect. And the key debate related to the coverage of small firms. That is also a very big challenge, because the act sometimes will applicable to the major organization and big industries, and small scale industries, something like that. So those industries, they are not unable to drive their business because of their labor laws is so stringent. So they are not unable, they are not to continue the business due to complaints part and all. So that's what the organization, the government, the central government wanted to make it a lot of provisions in the labor codes now. Some relaxation are there, some relaxation also there. So that is what now I wanted to run through. What are the industrial code which is helping in the both the end by the management side as well as the employee side. So these are the context I wanted to make it. Most of the labor law establishment over a certain period of time, the applicability will be typically it is 10 or more employees ordinarily employing in an organization. However, that is still discontinued. The size-based threshold limit may help firms in reducing the complaints and burden. However, one could argue that the basic protection related to the wages, social security, and working conditions should apply all the establishment, and certain codes retain such a big-based threshold limit. So now I will start with the IR code from Mr. We know very well that Tiruvalluvar is a person who was given before that code, labor code, whatever act and all, whatever he written on this Tirukural, which is containing entire world, the principles, everything is there. And from there, I picked out the 2 Tirukural. I just excuse me to know, I put into the Tirukural in Tamil format. I will explain what is that. The Kural number 1 is talking about Ankutram Niki, Pirar Kutram Kangin, Pin, Yankutram Agum Ireke, which means Irai means it is an organization. An organization which is ready to transparent, more transparent, and it is ready to go with a systematic way and ready to go with a disciplined way of the requirement as per the law. So there is no way to minding the other people, those who are disturbing the organization. So they has to establish, the organization has to establish the basic fundamental everything. Then he has to accept whatever the mistakes the organization is committing in front of violation of act, accepting and complying it, so that it is not to fear about any kind of violations from anybody from the employee side or employee sides and other side also. They can also set a role model for that. And second one is Idikum Tunayare Alvare Yaro Kedukum Takame Yavar, which means Tirukural, which is relating to the union. Whenever the union is very strong, the union is strong and it is indicating and no, the union is telling the wrong practices happening in the organization. So the organization should get the feedback the right way so that it can be set right the things and make a perfect relationship. So this is what about the Tiruvalluvar saying that the relationship, how it is maintained, what is the responsibility of the management, what is the responsibility of the workman side. These 2 Tirukural I took it for the example. And coming back to the labor law reforms, I already told that there's a 29 labor laws bring into the capsule format. It is into the 4 labor codes. The coverage I already told, the 10 or more employees is where the codes is segregated into wage code, social security industrialization code, occupational safety, and health and working conditions. So these are the 4 labor laws. And the synopsis of the Industrial Labor Codes 2020, it is considered in the Parliament, enacted in the Lok Sabha, and it September 22nd, 2020, and enacted by the Rajya Sabha the next day, 23rd September, and assented to 28th September 2020. It is published in the during 19th September 2020, introduced by the Labour Minister at that time, Mr. Santosh Gangwar. The first reading, it is read at in the Lok Sabha 22nd September, and second reading at Rajya Sabha 23rd September. So this act, this code, Labor Code, this code is repeal 3 major acts. One is the Trade Union Act 1926, and the other Industrial Dispute Act 1947, and Industrial Employment Standing Order Act 1946. So these are the 3 major acts it is repealing. So the current status is still there is a timeline was to implementation part at 1st April to 2021, but due to some the rules and regulations which is framed by the state government, concerned state government, even the act is central act, the rules is formed by the state government. That's why the implementation part still is not happening. So the date is already passed through from 1st April 2021. Now the government, the appropriate government, has to give the complete picture of the implementation part of the rules and regulations of the particular this code. So I already shown that the Lok Sabha, Rajya Sabha, and received the President assent on 28th September 2020. So IR Code 2020 is an act to consolidate and amend all relating to trade union, condition of employment, industrial establishment and undertaking, investigation and settling of industrial dispute, and a matter connected therewith, incidental thereto. This code is applicable to whole the India. So wherever the act so far we see read the labor law applicable to India except Jammu and Kashmir, but whereas this case, this code is applicable to whole of the India. So the labor code to consolidate and amend various laws into one single code is one of the important changes. So the no need to follow different act pertaining to the labor law, and to minimize the burden of the employer from the complying with the various acts. So a lot of, I already told that the various act is saying many rules and regulations and the compliance part. So all those things in different acts, and now it is going to be simplified format. As during the introduction, our professor said that there is a technology intervention as well as the scientific approach and automation process. This labor law also, this labor code also supporting for that automation, so that there's minimizing some of the records keeping, whatever the compliance part duties from the employer is completely minimizing that. To facilitate the ease of doing business, the business is only focusing on the making profit. That is only the motive, the business motive. So other than dealing with the issues with the workmen, issues with the government, so that is not the focus of the business. Now the business wanted to run independently without any kind of influences, any kind of issues from the employee side, issue from the government side. That's why the facilitation is done, the simplification is done. So the amendment, the law will be meeting the day-to-day requirement of, as of now, what is the customary practices, everything is eradicated. Now the only focusing on the what is required as on the date, that can be meet perfectly, so that that is one of the future of this labor code. And multiple registration, there is a multiple registration is required under the Factories Act, under the PF Act, under the ESI Act, whatever the act is required to registration and license everything. So now it is very simplified. There is a one license and one registration, so that we can operate the plant. So the renewal part and the license procedure, registration procedure is absolutely minimized. Coming back to IR Code 2020, 80 sections now expanded to 104 sections under 14 chapters. The chapter 1 is deal with the definitions. It gives so I already told that the lot of different acts is saying the different definitions for the workman, wages, and industry. What is industry and what is who is the employer? So different connotations are so far we are encountered, and now it has been simplified in the way of single definition for um, uh, many terminologies. That is one of the added advantages. And this IR code is provide the broader framework to protect the rights of the worker, to make unions, and to reduce the friction between the employer and the worker, and to provide regulations to the settlement of industrial dispute. This is one of the win-win situation based that this IR code has designed. So I already told that this code is consisting of three important, repealing the three important labor act, which is trade union, industrial employment standing order act, and industrial dispute act. So now only this labor code will replace everything. Objective is the code designed to safeguard the rights of the employer by providing the easy labor reforms and facilitate ease of doing business. Ease of doing business is an important connotation in the current business segment. Business should run without any kind of disturbance. That is one of the major motive of this labor code. The objective of the code is realize the industry peace and harmony as the ultimate pursuit in the resolving the industrial dispute, and to avoid and to advance the progress of the industry by bringing about the existence of harmony and the cordial relationship between the employees and workers. So scope and applicability, the code is designed to consolidate and amend the law regarding to the trade union conditions of employment in industrial establishment or undertaking, and seek settlement of industrial dispute. The code is regulate the sequence areas of the following. One is the formal procedure of registering of a trade union. You know, the trade union is one of the important stakeholder for the any organization. So they are one of the key influencer for the business smooth running. So there is under this code there is a lot of procedure has been implemented: trade union registration and the cancellation of the trade union, alteration of the name of the trade union, anything is required, formation of work committee, and incorporation of a registered trade union, and recognition of the negotiating union is one of the important aspect of this IR code. Preparation of standing order, there is some kind of relaxation given to the minimum small scale industries in standing order applicability, and register of standing order, constitution of industrial tribunal, illegal strike and lockout is very big setback during the ID Act and all. They're saying that illegal strike and lockout still the problem is continuing. Even the labor code is giving some kind of direction, but unless some kind of the cordial relationship with the union as well as the management, the strike and lockout is inevitable. So that point is still had to be clear by not completely secured the industry business viability, and still yet to there is a scope of improvement. So that we will hopefully expect some kind of reforms yet to come for this kind of strike and lockout. Procedure for retrenchment, there is a retrenchment procedure is there, and the re-employment for the retrenched worker, that is one of the important modification is done in the IR code. The compensation to the workers in case of transfer of establishment, that is also there. Prohibition of layoff, closure of an industrial establishment. In Indian context, comparing the last 100 years, whatever the industrial evolution happening in India, the start of the business is very easy. Any business, the business can be started very easily, and running the business also with a very difficult interventions and some kind of challenges. The running business also somehow the organization is able to come over, but coming back to closure, in closure of any industrial establishment, it is not so easy. That need a lot of protocol, a lot of legal remedies. Everything should be considered. There is a very big setback for the industry. So that is one of the things also it is taken in the higher code. So we are now, I'm taking everybody into, we'll go with the definition, how the definitions is giving the meaning as per the labor code. The industry, lot of definitions was there, but now this is the definition for the under the labor code. Any systematic activity carried on by cooperation between the employer and production, supply or distribution of goods or services with view to satisfy human wants and wishes, whether or not this is the following is not like any capital has been invested for the purpose of carrying on such activity. So that is not included. Such activity is carried on with the motive to make any gain or profit, but does not include in institutions and owned or managed by the organization wholly or substantially engaged in any charitable or social or philanthropic service, which is not comes under the means of the industry, and any activity of the appropriate government related to the sovereign functions of the appropriate government, including all the activities carried on by the Department of the Central Government dealing with the defense, research, atomic energy and space, any domestic services. So these activities is not comes under the industry, but however, still there is a scope of definition. Some of the establishment still comes under the industry, so there is no exemption. For example, in chartered accountant is running his business firm. There is no manufacturing activity, nothing is there. Still employing people as per the 10 or more people are there. So they will be still treated as an industry, that there is no exemption. Still this continues that. So some kind of reforms has to be going forward. That is to be not fully relieved from the definitions. So anyway, we'll wait for some kind of reforms after Industrial IR Code 2020 yet to come. The key definition means of employer. Employer means a person. Ultimately, employer is one of the most important terminology in any organization. So who is ultimate responsibility of for take care of entire affairs of the organization, as well as the legal representative for an organization. And employer means a person who employs, whether directly or through any person, or on behalf of any person, one or more employee or worker in his establishment, and where the establishment is carried on by the department of the central government or the state government, the authority specified by the head of the department in this behalf of where no authority is so specified. The head of the department, and in relation to an establishment carried on by the local authority, the chief executive of that authority, and includes in relations to establishment which is the factory, the occupier of the factory. The occupier, which is mentioned in the registration of the organization at the time, as well as the renewal of license. We are mentioning that occupier, the name, everything. He is ultimate responsible for entire affair of any affair of the organization. So he is liable for issuing any cases and appearing before the court for any pendency. He is ultimate person. Where a person has been named as a manager of the factory, the occupier is still there. Even the occupier is there. There is one of the terminologies called manager also is to be specified. In relation to any other establishment, the person who or the authority which has ultimate control over the affairs of the establishment, and where the said affairs are entrusted to the manager or managing director, such manager or managing director, contractor, and legal representative of the deceased employer. Now, coming to that IR code, the contractor also one of the party now. He is also made as an employer of the. So far, he is named as a contractor only before prior to this code. Now, the contractor is one of the employer, which IR code is defined. And coming back to employee. Employee means any person other than the apprentice. Apprentice is excluded under IR code, under Apprenticeship Act 1961. Employed by the industrial establishment to do any skilled, semi-skilled or unskilled manual operations, supervisory, managerial, administrative, technical or clerical work for hire or reward, whether the terms of employment be expressed or implied, and also include a person declared to be an employee by the appropriate government, but does not include any member of the armed force of the union. So this is the definition on the employee as per the hire code. Coming back to workman, so whatever the name so far called workman, you can mention any of the act in 29 Act already there. Factories Act, ID Act, Minimum Wages Act, ESIP, whatever is there. So far, the term workman was there prior to this higher code. Workman, now it is renamed to worker. So the word workman is already gone. So once this coming to the existence of the higher code, so it is referred to only the worker, which means any person except an apprentice employed in industry. Apprentice not comes under the worker category. To do any manual, unskilled skill, technical operations, clerical and supervisory work to hire or reward, whether the terms of employment be expressed or implied, and includes workers, journalists, and includes any such persons who has been dismissed, discharged, or retrenched or otherwise terminated in connection with or the consequences of the dispute, or whose dismissal, discharge, or retrenchment has led to that dispute, but does not include any such person who is subject to the Air Force 1950, of the Army Act 1950, or the Navy Act 1957, who is employed in the police services, or as an officer or the employee of the prison, or who is employed mainly in the managerial or administrative capacity, and who is employed in supervisory capacity, drawing wages exceeding 18,000 rupees. I just reiterate, 18,000 rupees, actually it was prior, before implementing this IR code, this was 10,000 rupees, now it is enhanced, IR code 2019 enhanced to 15,000 rupees, and now IR code 2020 is saying that 18,000 rupees will be the wage, capacity of drawing wages exceeding 18,000 rupees per month, or an amount as may be notified the central government for time to time. So this is as of now, to IR code 2020 is saying sealed with 18,000 rupees, the capacity of drawing. So under this purview comes under everybody is called as a worker, not workman. So coming back to the trade union. Trade union is one of the, I told, the important, unavoidable, inseparable clutches of the organization. Also, they are one of the deciding factor also for the smooth business of the organization. So, more importantly, this time this IR code is also touched on that some of the new amendments on the trade union per se. A trade union means any combination of either temporary or permanent, formed primarily for the purpose of regulating the relations between the workers and the employer, or between the workers and workers, or between the employers and employers, or for imposing restrictive conditions on the conduct of any trade business, and include any federation or two or more trade unions. This is the trade union meaning. And the IR code is also touched on the retrenchment. Retrenchment means termination by the employer of the services of the worker for any reason whatsoever, otherwise than the punishment inflicted by the way of disciplinary action, but does not include the voluntary retirement of the worker on reaching the superannuation, and terminates the services worker as a result of non-renewal of the contract of the employment between the employer and employee. This will be applicable for the FTE, fixed term employee. So this the point number 3, termination of the services. And standing order means it's the standing order also one of the code comes under the IR code. So that is also some kind of amendment is there. So this order relating to the matter set out in the first schedule of the this IR code. Coming to the registration part of the trade union, any 7 members, any 7 member or the more members of the trade union subscribing their names, apply the registration to authority according to the rules of the trade union, and at least 10% of the workers are under the workers. For example, in an industry have around 500 workers are there. For registration of the trade union, you should at least 10% of the 10% means should be 50 people. Otherwise, 10, whichever is less. For example, if 100 people is there, they can go registered, or otherwise 10% is coming to that, they are also going for registration, whichever is less. Must be the member of they should be they should be the member of the union. All the workers should be belongs to the particular union. There should be the member of the trade union, and during the date of making the application of the registration. So that is must now. Registered trade union shall continue to have at least 10% of the workers or 100 workers, whichever is during the registration, and should continue not only for the registration per se, even after the registration also, the union should sustain the members of the particular union. That is most important. If the name of the trade union is proposed to registered identical, for example, if during the registration, if 2-3 unions are there in the particular industry, so they are already one union registered one name. For example, CITU is there. That union already registered. The same name cannot be registered by the other party. So they should go with the alteration of the other name only. The registration authority will not allow for them. And coming to the works committee is still continue. Works committee already there in the as per the industrial establishment having more than 100 people. There should be a works committee. Works committee should be there. The committee will handle kind of individual grievances and settling the grievances amicably. That is the purpose of that. It may require to constitute a work committee to promote productive measures for securing preserving the sensible relations between the employer and the workers. So one of the committees still it is continued, but IR code is supporting the grievance redressal committees. One of the new thing is implemented. IR code, industrial establishment having 20 or more workers shall constitute one or more grievance redressal committee. The grievance redressal committee, either it can be a one committee or the committee may extend one more committee also. It depends upon the requirement of the organization, and the members, 10 members is the maximum resolution for passing any resolution of the dispute. 10 members should be there. This is for arising out of any individual grievances. Applicability, the works committee is 100 workers. More than 100 workers are employed and have been employed in any day preceding 12 months. The authority to make the general special order is appropriate government. The government may feed the appropriate government to formulate the committee. They can give the pass and order to form the committee. The government may require the employer to constitute the committee by sending the written communication to them. The composition should be the representative. The committee constituted with the equal representation by the employer as well as the workers engaged in the establishment. The condition is representative of the worker should not lessen the representative of the employer. This is one of the important criteria committee. The workers number should be more than the employer side. That is one of the mandatory condition. Selection of the representative of the workers may be consulted with the existing trade union also. So that is also one of the provisions allowed for that. And this coming to the grievance committee means applicability is 20 workers are more than 20 workers are ordinarily employed. This code is GRC, Grievance Redressal Committee, is allowing to formulate in the any GRC for resolving the disputes arising out of the individual grievances. And composition is maximum 10 members. Same kind of works committee, representative for the employer and workman. And most importantly, this GRC is specifying and insisting that there should be the adequate representative from the women's side. So that is one of the important amendments. Among the illustrations, for example, these are some illustration I'm just giving for our understanding. For example, there is a ratio of 200 and 300, 200 female worker and 300 male workers is there. The ratio should be, the committee, GRC committee should be 2:3. For example, 2 female and 3 male workers. It should be considered the formation of the committee. Assuming that the GRC has 10 members, for example, 10 members is there, and 5 members from representing from the employer side, That is no issue. And another 5 member, that should be from the worker side. And out of 5 worker side, out of 5, there should be 2 from the women's side. So women worker should be 2 people from the 5 members in the GRC committee. So this will be accepted norms by the appropriate government has set for that norms for that. We should any industry should follow for this GRC committee. This is one of the illustration given committee. The selection of the chairperson, representative of the employer and workman alternatively. Actually, for example, one period, the GRC committee, the representative of the employer side can be a chairperson, and the next terms, once its period is over, for example, 12 months or is setting the period, and he should be, the employer should give the way to the workman to occupy the chairman position. So it should be rotation basis. So procedure for filing the dispute is, an aggrieved worker, for any worker is aggrieved, he shall file an applications within 1 year from the date of on which the cause of the action as such a dispute arises. Within 1 year, you should file the application, and that GRC should find the proceedings on the dispute within 30 days of the application, and the decision should be based on the majority view of the committee. For example, 10 people are there, the majority, more than 5 people, 6, 7 people are saying that the decision, that should be acceptable way. This is a GRC methodology to find a solution on the dispute. The conciliation means it goes to the aggravated, the person, if the GRC is not giving the proper solution, or the aggravated worker not satisfied, the guy can be approached the conciliation, agreed by the decision by the GRC, or where it is not resolved, the worker can file application to the conciliation through trade union. He can file a case either by himself or through union within 30 days or 30 or 60 days of the respectively. For example, if the decision is not arrived by the works committee, so then it goes to 60 days, and it is not arrived by the grievance resolvers committee within 30 days, it should go. This is the time limit. The applications to the tribunal within 1 year. For example, if even the conciliation proceedings not helped for that aggrieved employee, he can be approach the application to the tribunal to the within 1 year from the date of action expiry at the conciliation stage. He can approach the tribunal within 1 year and making the application to the conciliation officer of the appropriate government. This is another illustration. As in the GRC committee, 10 members, 5 members representing the employer side and 5 members representing the worker side. And condition number 1, decision has to be based on the view of the majority. For example, more than half of the member representing the workers must agree the decision. For example, if the decision of 5 people are there from the employer side and 5 people from the worker side. From the worker side, yeah, Salachana, you are raising something.
So you move for you.
Someone raising.
I think Sulachana. Maybe he don't know, sir. I think he some click on. You just forward, sir.
Okay. Please no, give me a pause if I'm going fast or something you are not clear, and please get in interaction with me so that I can able to clarify. Okay. Coming back to this majority from the worker decision. Actually, any grievances, even the GRC committee is constituted with the 5 members from the representative for the employer side, and the majority of the worker from the 5 people, after the, for example, 3 workmen is insisting some decision, that should be validated and should be go with the decision. That is a scenario number 2. For example, scenario number 2 is the majority of the worker side is less, then the decision will be passed. Where 6 people are agreeing, including the representative of the employer side, and majority is 6 numbers, and the representing from the worker side is less than the 2 means the decision can be resolved, passed on. Similarly, here in the scenario number 1, majority is 7 and 3 number from the worker side, the decision should be considered from the worker side. There is some kind of comparative statement within the works committee and grievance redressal committee. The workers, number of workers is 100 for the works committee, whereas the GRC grievance redressal committee is 20 numbers. In the works committee, only one committee, whatever the number is there, more than 100 employees or and above, the works committee should be only one, whereas the GRC can be more than one or more than one. It depends upon the organization, depends upon the need of the particular industry. So that can be considered. And chairperson, here in the works committee, there is no specific chairperson, but here is grievance GRC, there is a worker representative, the employee representative should be on the rotation basis. The application for conciliation and tribunal, there is no application, it is not there. Here, the tribunal, the workman can make an application directly. The composition of the committee, more worker in works committee, but in GRC is equal representation, 50-50. And coming, excuse me. Yeah. Coming back to the recognition of negotiating the trade union, it's one of the most important segment of the IR code. Union, as you said, everyone knows that it's a very powerful clutches of an organization. The union is making a lot of if the relationship between the union and the workman will be smoother, that could be a very good for organization for further development. But in the other way, it will be very difficult. So that this code is facilitating some kind of recognition on the negotiation. Trade union also there. For the registered trade union, there should be a negotiating. Even the trade union is there. The negotiating the team, that should be the council to negotiate with any kind of demands or any kind of requirement from the organization. There should be a negotiating council among the union, that should be there. If only one trade union of the worker registered in the industry, so for example, in an industry engaging more than 300-500 employees are there, and there is only one union is there, and with a full majority, so that union will be the recognized union, and that union will be the negotiating council, both. So there is no other people involved for that, for any kind of negotiation with the management and all. So it is fair enough that the single union policy will go. So most of the organization in India, they're preferring for this single union organization and with the proper relationship and ensuring the proper relationship. For example, I personally felt that I working in the Dalmia Cement at Trichy. The organization is still for last 7 decades, 6 decades. There is a policy of single union. So it's a win-win approach. Definitely there is no waste of time, and there is no kind of ambiguity, and there is no any kind of I don't seek dirty politics over there. And it's very ease of operation, and the more understanding with the union as well as the management. So more collaborative approach, and those kind of things will be there. So that is there, but very difficult to keeping the union, one single union with all across. It will the expectation is more, the setup will be more, the dynamic will be keeping and changes. So that it's very difficult to keep the single union policy, so that the recognition is taking into the place for that. For example, if an industry having more than 1 or 2 unions, so there will be a big fight will be among both the union. So who will be the recognized body, and who is going to be sitting in the negotiations? All those things will be coming up. So for that, the IR code is facilitating how this kind of recognition and how the negotiations council will be formed at all. So this is also one of the very good amendment is in the IR code. the union negotiation as well as the counseling body. So if more than one trade union of the registered worker in an Indian establishment, then the 51%, for example, and in industry having the 300 people, okay, 51%, 150 plus, 151 plus, something like that. That team having the established that members subscriptions and union transactions, submitting the forms to the organization and submitting the forms to the trade and authority. So everything they are maintaining very well, and so establishing that numbers is more than 151 in 300 numbers of union industry. They are straight away treated as a recognized union. No secondary thought. They are the bargaining capacity. They have the full rights to have negotiated the union, and there is no issue. And if again, if multiple union setup is there, for example, 300 union members are there, one union already full majority is there, and other 51% is not there. For example, there is a spread, employee spreads is there. 300 people are there, 3 union are there, each union having 120 or 100 or something like that. So altogether it is 300 numbers. For example, there is a 3 union, they wanted to be a part of the negotiating council, means the members, the union, particular union having 20% of the population. Each 20% have one representation from the particular union. For example, in union A having 80 people, so 20% means they can out of 3 people they can represent, and union B 120 people are there, they can represent 4, something like that. So each 20% one person can be represented. So the collective members from the different union, they can form a committee council to negotiate with the organization. This is one of the amendment is given, the percentage is given 51% and as well as the 20% of the rest of the union. So the formation of the negotiation council. So some of the requirement for the registration of the trade union is any composition of 7 more employees, maybe by may subscribing their names to the rule of trade union, and by otherwise complying with the provision of the code of the applicable provision of the code, what the code is saying, as I explained, the 20% or 51%, whatever, whichever is applicable for the particular union, they can apply for the registration. And trade union of a worker should not be registered unless at least 10% or 100 workers. This is a base minimum mandate. For example, if they have 100 workers, no issue, there is no percentage at all required. And 10%, whichever less, is competing with the entire population of the organization, entire workforce, the 100 workers are 10% of the population, whichever is less, they can go for the registration. And this is one of the condition. Application should not be after making application and before registration, if not more than half of the total number of people applied ceased from the membership. For example, during the application, for example, 100 people are there. 100 people during the application, and 50 people is coming out of union during registration. That application will be invalid, so will not be considered for the registration. Some of the requirements: name, objective, utilization of the general fund, members list, inspection of the members list, admission of ordinary members, how the admission procedure, subscription of the amount, what is the percentage of the amount is deducted from the salary, and what is the sequence, what is the procedure, and the benefits, fine, meeting conductions, what are the periodicity of the meeting, and the election of the office bearer, how they are conducting the election, how they are selecting the office bearers, and the safe custody of the fund, how they are keeping their fund the safe custody. There should not be any misusage of the fund from the workers' subscriptions, and annual audits, that's must. has to be provided in the constitution. So those are the things has to be submitted before the register for applying during the registration of the union. Application to the registers, every application shall be accompanied by the declaration. That's the most important. The declaration is must. Rules and resolution passed. The rules and what are the rules and the resolution of the during the for formation of the union? What are the resolutions passed? What are the rules, guidelines for conducting for running the union? If the trade union is federation, for example, federation means more than the union is located various other industries, other part of the units also, the same union in other state or something, the federation also there, the central organization, resolutions adopted by the members of each member has to be submitted. Each member has to be give the resolution. That is also one of the important aspect of the registration. The trade union is existent since more than a year before making the applicant for registration. A statement of asset and liability also to be annexed. For example, the union is formed already. The union is already formed for the running for last more than a year, 2 years, but it's not registered in the union, trade union. If they are going to be registration means they should showcase everything. What are the points I mentioned in the before? The fund utilization, the transactions, the rules and regulations, the meeting, whatever thing, they should be go and submit with the and annexed with that, and there should be go for the registration. And register may call for the additional information for even submitting all the documents with the registered. They can call for some kind of additional information required, the alteration of the name of the trade union if any is required. If the union is submitted the same name for the existing union, so that kind of things he will call for the any kind of clarification and suggesting for the alteration of the union names or something like that. So these are the procedure for the register of the union. And coming back to that, and registration of the trade union is on satisfying the requirement. What are the requirement which is stipulated earlier? If everything is satisfied, the registrar will register the trade union by entering the register and issue the certification of registration. So conclusive evidence is the certification of evidence registration. He will issue the registration. So this is one of the point is where I don't know whether all the industries having the union, they are verifying the certification of the registration or not, but it is one of the rights for the organization. They should ask the union to submit the registration certificate, and if it is valid, if it is renewed properly, everything have the rights to the organization to. This is for the in the context of the recognized union. For example, if the organization is recognizing the union, so the organization have all the rights to produce all the documents, certification, everything for to continue with the recognition. And coming back to the trade union register under the Trade Union Act 1926, and valid registration will be deemed to be registered under this code. Even the union is registered under the Trade Union Act 1926. The IR code is demanding that it should once again it should be registered under this code also. It submit the statement that it's constituted in the accordance with the code. Trade union shall be a body corporate with the perpetual succession and common seal to acquire and hold the properties under issue and to be issued in its name. Any kind of a conflict arised, any kind of with the management, and the union is liable to receive the legal notices, and also the company can issue any kind of disciplinary procedure. So the union wanted to go for the legal remedies, they can send a legal notice to the union. On voluntary application of the trade union, the cancellation is if any union they wanted to cancel the registration, they can go with by voluntary. They can submit their voluntary applications. If the trade union not followed any regulations, rules and regulations, any guidelines stipulated by the appropriate government, any contraventions of the act saying that, so it is liable for cancel the union. If composition of trade union is not in accordance with the code, the register shall withdraw he can cancel the registration, and 60 days notice can be served to the notice starting to the ground of such actions shall be given by the registered to the trade union. So within 60 days, you can either cancel the trade union in contravention to any of the code defined the regulations and all. So there is no notice will be sent to them. Straight away it will for voluntary application. If any trade union wanted to cancel the union, the notice can be no notice will be sent by the trade registrar. The registration shall also cancelled by the order of tribunal. Appeal to the tribunal. Coming back to the appeal to the tribunal. When a trade union can go for the appeal, it is applicable for all sort of the even union. When the registration is refused by the registered authority, when the union apply with all the following with all the protocols, all the regulations as per the code, they're conducting meetings, they're collecting funds from the organization, they have all the subscriptions, they have the declarations, everything there on the own, even all the proper documents submitting to the registration. If it is not accepted, it is refused by the registrar, and they can go for the appeal with the tribunal. Or if the registrar is cancelling that trade union registration by his own without any notice, cancelling without any valid ground, so that kind of situation also the union can go for appeal for the tribunal for the legal remedies. Appeal after the limitation period, a tribunal may entertain such appeal and showing sufficient reason for delay. For example, if the trade union not getting the registration on time, even submitting all the documents properly, the tribunal will demand the trade union registrar to showcase what ground the reason, what the reason the delay has happened, why it is not happened. So all the rights have the tribunal have the rights, and the trade union registrar has to liable to explain, showcase their explanations, the ground of delay or cancellation, whatever may be. The parties concerned will be given opportunity of being heard before passing an order, and tribunal will forward a copy of order to the registrar. The communication is one of the important parts where once from the trade, the communication either way from the registrar to the trade union or from the trade union to the registrar or the vice versa. The communication, the notice shall be sent to the head office address from the registrar to the trade union, which are the register address to the trade union, and from the trade union to the registrar is where the composition of the trade union falls below the statutory threshold, or for any changes in the particular since the time of the registration shall be informed to the registrar. Non-applicability, for example, the following, these are the few acts which is not entertaining the trade union. Following action shall not be applicable to the registered under the trade union. One is the Societies Registration Act 1860 and Cooperative Society Act 1912, Multi-State Cooperative Society Act 2002, and Companies Act 2030. These are the exempted from the registering the trade union. And coming back to negotiating union and the council. This part already I have explained clearly how the negotiations, what is the minimum mandate requirement for the negotiating the council and all. And industry establishment having one trade union, the employer must recognize such a trade union as a sole negotiating. I already explained. One single window system. There is only one union at any organization. There is no issue. And more than one trade union registered under this code. and 50% more, 51% actually. It should be a 51, more than 50. Workers should be on the muster roll, shall be recognized the sole negotiation of the organization. If more than one trade union, if no trade union has 50%, there is no strength for the 50% for the majority, there should be the 20%, one representative for the each 20%. That is also there. I already explained. The term of the recognition, the union is recognized that the period may be range from 3 to 5 years, in between 3 or 5 years, maybe, and the period of the union can be as per the union resolution, the rules laid down, the union resolution also they can pass out whether the period of the committee, the union period will be 3 years or 5 years. They are also mentioned that accordingly the period will be maintained. This is one of the important parts where the IR code is also touched on the standing orders. Standing order, you know very well. The standing order is one of the important guideline, and it is maybe it is like a Bible, Bhagavad Gita or whatever may be for the organization. It's most important instrument to control the terms and conditions of the workmen in any industry. An industrial establishment having employed 300, actually the number is sealed now, 300. Very big is a very big relief for the small industries, small scale industries. Standing order is must for all the industries where they should adopt a standing order or certified standing order or model standing order as per the Standing Order Act. Those are the two terms. There are no other industries exempted from that standing order, which is one of the things under. And standing order formation certification will be a very difficult part in any organization. It's not a very easy job. For obtaining the standing order, to lay down the conditions and the terms and working conditions, terms and conditions of the business as well as the employees side, agreeing itself is a very big challenge. Make them to understand by the union and the members, agreeing all the terms and conditions will be a very challenge. And even after, if it is agreed by the mutually union as well as the management, sending to the certification to the authority and getting the certification also is one of the biggest challenges in Indian context. Not in Indian context is very difficult because of lot of factors are involving on that. So not easy to handling the government official easily. Government officials always looking into that favor from any organization. Sometimes some of the organizations are very lenient, very fluctuate to handle such government officials, and some of the organizations very straightforward. They're not even consider any kind of favor to getting anything approval from any organization. So those are the very big context in Indian industries. So some of the organizations are adopting their own style to getting things done. But however, this IR code is giving very big relief, not only for the IR code, the entire labor reforms. The entire labor reforms is one of the biggest relief is all the inspectors, all the government officials connected to the organization, connected to the running the business, either maybe a factory inspectorate or the labor officer or any kind of commissioner from the labor department, anybody, whoever may be. So far they are exercising their own power and kind of working on the style of the organization, how they are taking care of it. Now the thing is, the inspectors now become the facilitator in this context. It's one of the very big relief for all the industries. So they can advise to the management. They can go and sit, understand what is the organization is now doing, whether in line with the parameters of the labor codes. The labor code saying that what are the rules and regulations organizations to follow that they are doing it, or any violation is there. If it is found, there is not a show cause notice or immediately to send show cause notice to the occupier or manager, something like that, which is in the previous Factories Act, whichever may be. But now it is facilitating that these officers will be the facilitator. They can come and advise. So whatever the negligence part or whatever the area of improvement or whatever the non-compliances area part, so they can advise. They can advise the management to fulfill the gaps, so that the power of exercising the authority will be minimized. So this is one of the very big relief for the entire industrial organization point of view. And now coming back to the standing order, also having employed more than 300 only now, that there is no less than 300 employees working in an organization. Even also they also might follow either standing order certified or the model standing order as per the act. But now the very big relief is 300 more only eligible for applying for the standing order. That is one of the biggest relief. That's what I wanted to try to make it, because I know the personally how difficult the standing orders preparations and getting approval and driving the standing order, driving the client in line with the standing order classes and all. So it's one of the most important. That's why I'm spending more time on it. The standing order must prepare the standing order on the following matter. The subject also is very clearly, it is narrated in the higher code. The classification worker should be there, whether the worker, whether he is a worker or badli or apprentice, whoever may be, the classification of workers should be there properly. And the manner of intimating the workers, workers for hours of working, that is important. And holidays, pay days and wage rates, shift for working, everything should be. Sometimes standing order is not demanding for the wage rates in shift working, that is not there. But now the pay days also there, but the wage rates and shift working also should be marked in the standing order as per the new standing order, new higher code. Attendance, what is the attendance system is there, that should be comes under the standing order. Condition procedure for leave and holidays, what is the condition, how to avoid the leave, and what are the procedure to adopt the holidays, that is also there. Sometimes a requirement to enter the premises, how the organization is bringing the people from outside, whether they're engaging buses or the employees coming their own, and how the entry procedure in the gate and the liability, all those things and all. It should be clearly laid out in the standing order. And coming back to the most important aspect of the powerful weapons of the industrial context, strike and lockout. Very every people are hesitate to talk about. I mean, not interested to talk about the strike and the lockout on the any organization don't like to go for strike and lockout. This is one of the most important. But previous that, no, there was there is no clear-cut mandatory, and the procedure was there. Whether the strike in the private organization or strike in the public organization, different approach by the government was there. But now, for example, strike is happened in the public sector, will be treated separately, and the strike is happening in the private sector, and that too also in the private sector, the strike in the large industry will be noted and notified in a different manner, and the small scale industry and medium industry. So it depends on the size of the organization. The strikes and the lockouts will be treated in different connotation by the appropriate government. Now this code is completely given some kind of uniformity bring into that, whether it could be a public sector or private sector, doesn't matter. The strike and the lockout, both the terminologies will be applicable for all the sectors, either small scale industry, medium scale industry, a large scale industry, or the public industry, whichever may be, immaterial. Now, coming to the strike, every person employed in an industrial establishment is prohibited for strike and lockout in breach of contract. For example, if they go for any illegal strike or illegal lockout, there is not a permittable. This very clearly it is mentioning that. And without giving 60 days advance. Earlier it was 2 weeks notice, but now 60 days. So 60 days notice is one of the very big relief for the organization. And any workman wanted to go for a 60 days strike, go for a strike, they should serve for the 60 days in advance notice. And similarly, and the vice versa, the employer also for lockout also to be the same kind of thing to follow. Within 14 days of the giving such notice, if even the strike notice is given by the union, go for a strike, and within 14 days there should not be any kind of disturbance. That is a very mandatory. If it is go for any strike before 14 days, should be prosecuted. That kind of a stringent process is coming. It is brought down into that IR code. It's one of the biggest change in IR code. And before the expiry of the date of the strike and lockout specified in such a notice, or during the pendency of any conciliation, either conciliation proceeding before the conciliation officer, and 7 days after the constitution of the, for example, if the negotiation going on between the workman, between the union as well as the management, and there is no resolution, there is no amicable settlement happened, and the matter referred to the conciliation. The matter is pending before the conciliation, and then the union resorting for the strike, that is illegal, that is not permittable. And similarly, the organization, if not happy the way the discussion going on, whether in the before, either in the negotiation within the premises, and the negotiation happening during the before the conciliation officer, and out of frustration the company is going to be locked out, that's not acceptable by the organization. That is lockout is not permittable for that. And similarly, if conciliation failure and still the matter referred to the arbitrations and pendency before the arbitration also, this will be prevent for any strike and lockout. This is one of the most important facility, important provisions which is enacted to that new IR code. And this is the most important thing, change of condition of service, section 9A of ID Act previously. Very, is actually is a very big setback for the organization. For example, the change of condition of service will be the very big setback. There is no further, the union also misusing that this provision, unable to take it further the next level to the organization development and growth. For example, change of service condition. Normally, the change of service condition is it is give the guidelines for the organization, not impacting the working and the employment of the any individual, and not impacting the wages or working hours, something like that. They wanted to the purpose of the service condition of service is to protecting the workmen exclusively on their wage part, exclusively on the employment part, exclusively of their time working hours, something like that. These are the preliminary. But moreover, for example, if I wanted to shift my one of the for example, one small operation, I'm going to be automating it. Automation is going to be happen. For example, a person is working by manually on operations. For taking operation is there, where he is doing operation by his hand. The organization wanted to minimizing the manual effort, the employee manual operation, and the organization wanted to facilitate the particular workman, and also it is helping the organization for the speed of the operation as well as the ease of operations and time saving and all those things and all. Some automation is going to happen. That time also the union is completely coming into the picture and they are refusing it to accept the further change of conditions. So because this service section 9A will be they are completely giving the free hands to the union not to incorporate any kind of changes in the working area. That is one of the biggest setback. However, now some kind of IR code is now some taken to the picture that so wanted to considering the growth of organization, they kind of some kind of changes as incorporated here. The employer is required to send the notice change in the condition of service, the matters to the workers being affected. So he has to send the notice, and wage and compensatory any other allowances if it is there. It is pertaining to exclusively on the wage part, compensatory part, and other allowance, any allowance part. If it is affected, the employer should send the notice of change to and the condition of service to the union. And contribution paid or payable by the employer to any provident fund or pension fund or for the benefit of the workers under any law for the time being in force. The second thing. And third thing is hours of work and rest interval. If any alteration, for example, I'm going to increase the working hours by 8 to 9, it's not legally, it's not possible, but that cannot be do it. If hours of work, for example, in particular operations required, minimum 1 hour to stand alone to monitor that operations. If organization wanted to increase 1 hour to 1.5 hours, if that working hours I'm talking about, so that working hours is increasing any by half an hour or 1 hour, it is increasing. That has to be notified to the sending the letters to the union. The rest interval, redefine the rest interval, reducing the rest interval. There is a 20 minutes going to be reduced to 15 minutes, something like that. That is going to be notified. Leave with wages and holidays, any alteration were agreed. Leave with wages, any kind of things are agreed. The settlement it is there. Clearly, it is mentioning holidays, wages, leave, everything is there. But despite that, the management wanted to amend. They had to give some notice to the union before going to touch on that. The starting altering and ending of shift operation, otherwise then according to the standing orders. So these are the points to be taken very, very carefully, and the matters has to be communicated to the union by change of change of notice orders. Classification by grades. Any grade changes is there. Withdrawal of any customary concession. For example, I am practicing some customary practice. It is not mentioned as per the act. Some kind of customary practices I am doing it, or privileges of modification, uses of introduction of the recent provision of discipline, or alteration of existing rules, or except in so far as they are providing in the standing orders. Rationalization, standardization already I explained. Any standardization is there, like TPM, adopting the TPM. TPM is one of the tool where the continuous improvement for the organization. So standardization is an improvement of plant or techniques that is likely to lead the retrenchment. If by doing this, any kind of retrenchment is expected of the worker, or any increase of the reduction of the number of persons due to some standardization improvement, or to be employed in any occupations or process or in department or shift, not occasioned by the circumstances over which the employer has no control. So these are the area that change in the condition of service has to be notified. Coming back to the retrenchment is one of the most important point has been incorporated in the IR code. Retrenchment provides the procedure for the IR code is provide the what is the procedure for the retrenchment of worker and the re-employment of the retrenched worker. That is also re-employment for the retrenched workman also talks about in the IR code is one of the amendment. For the retrenchment, the employer must either give the 3 months notice or pay the retrenched workers in lieu of the notice period. Where any worker is retrenched and the employer proposed to take into the employment, any person within 1 year of such a retrenchment, an opportunity will be given to the retrenched worker who are citizens of India to offer themselves for the re-employment. The retrenchment, there is once the employee is retrenched in any organization, within 1 year there is no scope for re-employment. That was not there earlier, but retrenchment as per the idea it was there. But now the IR code talks about if an organization wants to rehire the retrenched employee within a 1 year, it is possible that IR code is permitting that a person to re-employment within a 1 year. That is one of the clauses favoring to the workman. Now layoff. Most important aspect of the IR code is on a layoff. Everyone knows that layoff. What is the meaning of the layoff? It's the inability or employer by the giving employment to a worker due to the multiple factors are there. This is a multiple factors, which means that the shortage of the coal, power, any breakdown machinery, very big breakdown in the machinery, the main part of the organization, main part of the plant in the factory, or breakdown, unable to run the business or unable to run the plant. These are the conditions laid on clearly. It is layoff. But so far, the layoff is applicable for organization wherever engaging 100 and more. This is one of the condition. 100 and more layoff should be get the permission from the appropriate government. Without a permission, layoff cannot be possible. That is one of the condition provided before this IR code taken to picture. But it's a very big relief for the small scale industries, medium scale industries, even those wherever employing less than 300 employees. So this IR code is giving big relief for them. Layoff is not required for any permission, official permission from the government to declare the layoff, where less than 300 employees are there. If the layoff is only applicable where 300 and more employees is working in any industries, they should go for the formal approval from the private government. This is one of the big relief for the non-seasonal industries as well as the medium and small scale industries. And there should be the 50% of basic wages and additional allowances to the worker who has been laid off, give 1 month notice or wages for the notice period to the retrenched worker. This is one of the conditions. And non-seasonal industry establishment with at least 300 workers is required to take a prior approval from the central or state government before layoff. Retrenchment I explained. Prior approval before layoff, retrenchment or closure is required by the non-seasonal industry establishment with at least 300 workmen for central and state government. And coming back to the closure is one of the, still there is a scope of the IR code, but not so clear on that. The closure format is still not favored to the organization, but still some kind of improvement amendments is there. But closing the plant is not so easy. It's very difficult. I already initially told. Closing plant is not so easy. The company has to underwent a lot of legal procedure that has to be adopted, and even then, this IR code is touched on some of amendments on that. Employer intending for closure of industrial establishment is required serve 60 days of advance notice to the government, and provision for the compensation in case of closure to those workers who are in continuous period of service is not less than 1 year. So the compensation to the workman who is working more than a year, that is also to be taken care on this closure part. Exemptions on this IR code, the code provides that the central or state government may exempt any new establishment or a class of new establishment from all or any provisions of the code in the public interest. The government may think fit, but that clause is there. Coming back to more important segment of that employment per se in IR code, there is a fixed term and fixed term employment is there. For example, but the fixed term employment is one of the area where the worker can appointed for a term of a fixed period. It should not be misused by the organization. For example, if industry is are starting, for example, new industry is starting with 100 manpower, they are appointing with the fixed term employees. All the 100 people are fixed term employees only for period of 2 years. Once over the period of 2 years completed, it doesn't mean that the fixed term employees will go and new workmen can be appointed with a lower cost. That is not permissible. That is not a meaning of that. Fixed term employees is only meaning, given the meaning on that, fixed term. It is referring the job, not the. It is a meaning for the particular activity. For example, the activity is the fixed term only. For example, 1 year the activity is there. After that, the activity is not there. So there, the employee worker is working there. They are called as a fixed term employee. So after a 1 year period, the job is nowhere. The job is not there. The job is completed. So no way to people performing there. The job is not there. The worker is not there. This is the concept. So the fixed time employee is completing. Employment is over. Then they can go out. So they can settle. This is the meaning of the fixed time employees, and doesn't mean that the fixed time employee can appointed in the regular operation of the plant, where the main stream of the plant is the a person is employed. It is the job is continuing for 5 years, 10 years. The fixed time employee is appointing that, and he will go after a year or 2 years. It is not permitting. So FTE is only based on the activity based, job based. The job is fixed time. Job after that time, the job is not there. That is the meaning for that. The fixed time employment will be allowed across all the sector. Now it is anybody can use this FTE. Fixed time employees will have the party in terms of employment working conditions. They are also treated as the same employee. Whatever the salary, benefits, PF, ESI, whatever is there, provisions, gratuity also it is now extended for the fixed time employees also. The gratuity will be paid to the FTE who works for more than 1 year. Even the gratuity is, when I say that 5 years period is now abolished. Now, even 1 year, the FTE is worked for the fixed time employee worked. He is eligible for gratuity as per the new IR code. The main exception is that retrenchment application should not arise when the worker's contract is not renewed on expiry of the fixed time. If, for example, the fixed term is no job is still continue. Okay, 2 years the job is continue. The terms and conditions agreed. The job is continue after 2 years. The contract is not renewed after 2 years means it will be the retrenchment can be done. The worker can be sent out because of non-renewal of the conditions of the agreement. So these are the FTE, one of the important amendment on the IR code. Some of the reason initially our professor said that there is a lot of system computerizations as well as the automations happening in the labor, government officials, and as well as they are connected to the various legislation. And now we can apply all the registration format. The IR code is provided to filing the applications electronically. So we can apply the registrations of any organization through online, and whatever the already started that the provident fund, the ESI, the contributions will be already there. They are remitting the payments by electronically. So now it is also the IR code also talks about any kind of registrations of the organization, renewal of the organization, the certificate, and everything can done through the electronically. The old act did not have any specific provisions of the electronic file, but this act now it is coming into the picture. Mostly the wage code, whatever the labor reforms recently happened, is the main purpose of the code is to ease of the operations. Ease of the operations time, reducing the times for the clerical work, all those things and all. Now the IR code also supporting that. Whatever the transaction with the government officials, going physically, meeting the people, now it is completely reduced. This is one of the biggest relief for the organization. The penalty classes now also touched on the penalty class in the IR code. There is a lot of penalties is now increased. For example, penalty have been substantially increased under the IR code. Example, the penalty and contravention of any section under section 70 conditions proceedings of the retrenchment of the worker under the IR code, a fine up to 2 lakhs. It is increased now. Whereas under ID Act, the penalty was 100 rupees only. Now it is 2 lakhs. It is improved. The compounding penalty is now possible for the first offences subject to the conditions. So some of the, just now rush to the time is now going to here. I'm going to comparative statement on that. What are the current law as well as IR code? Some of the comparative, I just wanted to recapture on that. So the definition part of a workman already said that the workman, it is renamed as a worker, and the supervisor also called as a worker now. Changes the wage ceilings in the supervisory workers from actually it was 10,000 rupees initially. Now 2019 industrial IR code 2019 talks about 15,000. Now it is 18,000 rupees. IR code 2020 talks about the wage for the supervisor category is 18,000 rupees. The definition of the wages also there. The definition of the wages refers to the monetary remuneration including dearness allowances, value of house accommodation and travel concession, excluding bonus, gratuity, and contribution for the business. And coming to that current IR code talks about the wages refer to the any remuneration, including basic pay, dearness allowances, retaining allowances, bonus, conveyance allowances, and overtime pay, except bonus, conveyance allowances, overtime pay, not etc. not included. Definition of the fixed term employment already we discussed just now. It refers to the worker hired for a fixed term. The worker's fixed term only for the job, not for the job is terms of the job is only the fixed, and after that job is not there. The who apply the same entertainment and the benefit as available by the permanent worker. The fixed term employee is also eligible to avail the benefit of the permanent employees who is working in the same industry and for a particular the fixed period. And coming back to provision of trade union will be registered only for at least 10% of the worker, and the same will be continued. Whatever the limitation is there, that is continued. Coming back to this one, negotiating union also, which was not there in the earlier Trade Union Act, but now IR code talks about 50% and 20% respectively. 50% for the majority. If majority is not there, there should be the 20% of the each union representation will be decided. Coming back to the strike and lockout, the Industrial Dispute Act for the public service utility, strike or lockout cannot be conducted unless a notice of 14 days is provided. The notice is valid to the maximum of 6 weeks. It was as per the ID Act, but IR code talks about that the same provisions on the strike and lockout have been extended to all establishment, irrespective of the public or private utility. The validity period of the notice has been now amended from 6 weeks to 60 days. That is one of the major changes in the strike and lockout per se. And layoff, one of the biggest relief. The current Industrial Dispute Act is talking about the 100 or more workers employed are required to take the permission for layoff, but now this 100 is now increased to 300. So we are below 300, no permission is required for declaring the layoff and retrenchment. So the thing is, no, everything is set right. Only the state government has to be give the regulations and all. So once it is done, then it is going to be implemented. But still, it is not under in force. Workers reskilling fund is one of the more important thing. Is, for example, a guy is retrenched. As per the current ID Act, it's not talking about anything. No provision is there. A guy is retrenched means he has to go with the retrenchment benefit only. Nothing is more than that. And IR code is now wanted to do some kind of favor to the retrenched workman. There is some fund will be consist of contribution from the employer equal to the 15 days of wages of every retrenched workman. For example, 50 people are retrenched from the organization. So 15 days of salary of the each 15 people has to be worked out, and the contribution from the other sources, any other sources will be there other than that. That is also adding to that, and prescribed appropriate government, you should be utilized as prescribed within 45 days of the retrenchment. A guy is retrenched from the organization within 45 days. he is eligible for 15 days of his last drawn salary as a reskilling fund. Is one of the new provision under the IR code. Model standing order was there. Standing order current law was there 100 more workers. One of the biggest relief I have said already. Standing order applicable on as per the Standing Order Act 1946. Only 100 people is there. It is there. They have to go for standing order. But whereas here now it is changed to the applies 300 numbers, sorry, it is 100 I mentioned, sorry, it is a 300 numbers, applies to the establishment employing 300 more workers, central government will draft model standing order. Employees must consult with the trade union or negotiating union council before submitting the order to the certifying officer. So here, in ID Act, Industrial Dispute Act talks about various bodies for the dealing with the disputes. A lot of bodies are there. For example, if any discussion, any things is failed in the industry, within the premises, goes to conciliation officer. The conciliation officer will be conciliated. If even the conciliation officer, the matter is not settled down properly, it will go to the court of inquiry, and then it goes to labor court, and then it goes to industrial tribunal and national tribunal respectively, whichever applicable, and tribunal to consist of judicial members. So this is the as per the ID Act. But now IR Code 2020 is facilitating that, it removes the conciliation, all those things, and now provides the industrial tribunal, national tribunal, industrial tribunal to consist of judicial member and administrative member. Now some kind of exclusion. There is no conciliation body is required, nothing is there. They can go to tribunal straight away. And here only the appropriate government can make a reference to the labor code. The any subject, any matter, appropriate government, for example, state government is appropriate government. If they can refer anything case to the tribunal and the central government to the national tribunal, state government to the tribunal and the central government to the national tribunal. Here IR code talks about either party to the dispute, either employer or the workman can approach the tribunal straight away. However, only the central government can make the reference to the national tribunal. National tribunal still it is under the purview of the central government. Whatever, but however, the IR code is facilitating either party from the management side as well as the workman side. Anybody can go for seeking the intervention of the tribunal. So, with that, I'm to the ending stage of this session. I think I also tried to convey whatever I learned from the labor reforms so far happened, and I just shared the things with you. And I hope that people thank you so much for your patience to understand very passionately on my speech. If anything I not clear, you can also get in touch with me. Then I can able to clarify now. With that, I'm concluding my sessions with that. Thank you so much for the organization in Bharatidas University and my team members associated with that. And extremely happy the way you people are listened to me and the way the subject which I was talked about on this IR code and all. Thank you so much. Now over to administrator.
Thank you, sir. Thank you for your valuable and wonderful speech. Now let's call upon Ms. Dharani for handle the question and answer section.
Yeah.
Dharani is there? Dharani?
Hello.
Carry on. Dear participants, if you have any questions, kindly put in chat box.
Hello, sir. Am I audible?
Yeah, Dharani. Good afternoon.
Yes, sir. One question. Good afternoon, sir. One question from chat box. Re-employment of retrenched worker. Kindly explain it, sir.
Re-employment, which means in an organization, okay, there is a retrenchment was there, and due to some kind of no organization requirement, the employee wanted to retrench, maybe an excess manpower that point of time, overpopulation. So downsizing some people, for example, 20 or 25 people are retrenched. Okay. As per the ID Act, retrenchment, Section 200, and the rules laid on over that. The retrenchment, once the employee retrenched, the organization should not appoint any persons over there. Because of that, the employee is retrenched from the organization, maybe a huge cost. For example, he is drawing around 30,000 rupees retrenched from services. The organization should not appoint a person with the 10,000 rupees and saving another 20,000 rupees. This is one of the background for that. So once the employee is retrenched, the position should not be filled for some time. But now the IR code provide a facility saying that the employer can give the re-employment. If, for example, that particular operation is renewed, somebody wanted a particular operation after the retrenchment, the management, the organization wanted to perform the operations, and they can take back the retrenched employee even before 1 year. So before 1 year, after 1 year, only if they be considered. But now the IR code is facilitate take back the employee even not completing even before 1 year also. You can appoint rehire, re-employment can be considered for that. Understand what I am saying?
Yes, sir.
Yeah.
Sir, next question from Vignesh.
Yeah.
Still, minimum of 7 members is applicable for registration of trade union, or it has been withdrawn as per new code.
Now the registration is 10%. 10% of the total, for example, 10% are 100 people. Okay, 100 numbers are 10% of the total population. Whichever is less, they can go for registration. For example, 200 people are there. Okay, 200 worker are in industry, and 10% is 20 people. Okay, or the union have 100 people. So if they have 100 people, they can go for registration straight away. If not, they have 20 people, they can go for registration. Anything?
Hello, sir. Next question, sir. Hello.
Tell me, Dharani.
Question. What is the difference between retrenchment and layoff?
Retrenchment is layoff is nothing but layoff means there is a conditions. Some of the condition is going to be uh, stopping the operation of the plant. For example, consistently not getting the power or coal, raw material, or natural calamities. Due to that, the business is unable to run smoothly. For example, without raw material, how can run the business? You cannot run the business. If coal is important for the one of the important raw material for the fuel. If it is not there, so the business cannot be run. Any natural calamity because of the disaster happened, any earthquake or anything, something has happened, the plant got disturbed, unable to run the business, rebuild. So during that time, for some time, it will take some time. Now, for example, 1 year or 12 months or something like that. I mean, 1 year, more than a year. That time, 6 months, whatever may be, the organization have reserves using that layoff. They can lay off. During that layoff, the management is not pay eligible. Management is not paid to the salary to the employees. They can go for the layoff salary. There is a layoff salary. Is there? It's a clear cut. The layoff salary will be notified by the after the layoff. There will be a condition agreed by the labor officer. There should be a terms and conditions agreed. This is the salary, layoff salary till the reoperation of the plant. That has to be paid. There is no full wages eligible for the employee. So all those things are there. This is the layoff. Coming back to the retrenchment is nothing but retrenchment is a person will be dismissed from the service. Okay, due to excess manpower or something like that. Retrenchment means I want to retrench some people, excess people, unable to. For example, an operation is having only 10 people and having 25 people are there. I need to retrench another 15 people. So excess manpower can be retrenched, and it is not the punishment is not a retrenchment. It is something different. It is optimizing the people. Okay.
Okay, sir. Thank you, sir. And next question from Mr. Anjan Kumar. As we have registered and recognized trade union, is it mandatory to constitute works committee?
It's not required. Works committee, actually now it is now, if union is there, union is the wherever union is not there, okay, the works committee will take care. For example, the organization and the employees are very comfortable with the work with the works committee. The committee will take care of everything, the welfare of the organization, welfare of the employees, as well as the continuous improvement of the organization, everything taken care by the works committee. The works committee gives all the resolutions, all the solution to the particular issue. Then the union will supersede. Once the union will come into the picture, so they will take away the works committee. The limitations are there. The power and the limitations will be there, but union will have the more power. They have the privileges. They have the bargaining capacity, the certified bargaining capacity, and everything is there. So that once the union is there, the works committee, the power will be diluted, and there is no point to discuss the work committee. The work committee even agreeing certain point, and the union will be raising a dispute, and we have to find a way out, come out of the disputes and all. So that once the union is there, we have to the works committee not so no valid on that. Union is the ultimately take care of everything on that.
Thank you, sir.
Yeah.
And then some institute requirements are going on with consultancy base. There is so much salary difference there. So what can do employee?
Can you repeat, please?
Some institutes requirements are going on with consultancy base. There is so much salary difference there. So what can employees do? Hello, sir.
சொல்லுமா கொஞ்சம் அண்டர்ஸ்டாண்ட் பண்ணிக்க முடியல என்னால் என்ன கேட்குறீங்க. ஐம் நாட் ஏபிள் டு அண்டர்ஸ்டாண்ட் ப்ராப்பர்லி.
Some
percentage there.
institutes, sir,
சொல்லுங்க.
some
Yeah, tell
institute
me,
requirements are going on with. Sir, am I audible, sir?
Yeah, I'm hearing.
Hello?
Tell me.
Sir, some institutes requirements are going on with consultancy base. There is so much salary difference there. So what can do employee? Question from chat box, sir.
Okay. Now, what I am understanding means, so it is outsourcing. You're talking about outsourcing, I believe, correct? In industry, there is a two set of working people. One is the permanent employee, and one is the outsourcing activity. Some of the activity will be outsourcing. They will be taking care of the consultancy. For example, the housekeeping, there is one of operation. That operation, no need for the permanent employee to perform it. Even it was taken care by the permanent employee earlier, and now when looking at the cost reduction and all, the organization is looking out for some appointing the outsourced vendors. So very good service as well as the cost effective. So that time it will go. So that will not impact in the salary structure of the existing people. That will continue. Then the organization there is no rights to reduce the salary or benefit or welfare whichever agreed in the terms and conditions of the LTA, long-term settlement of the organization. That should be completely fulfilled. If anything to be, any salary or any welfare, anything to be reduced, there is a change of service condition. It is there. That's a section 9A notice as per ID Act, but there is a change of working condition also there. So I already explained that is to be intimated well in advance. That is to be agreed with both the party, union as well as the management. Then there is any resolution passed over there that has to be implemented. Otherwise, simply salary changes impacting of the outsourced organization into the any activity is a purely based on the need of the organization, nothing else.
Okay, sir. And so Mr. Vignesh is asking for a clarification regarding the the provision of for strike. Strike cannot take place within 14 days and after 60 days of giving such notice. Is his understanding correct, sir?
Yeah, the strike means 14 days notice was there initially. Okay, now it is increased to 60 days. Any strike, if the strike should be taken earlier, 14 days notice was there as per ID Act. Okay, once the union submitting the starting strike, then they have to go for strike after submitting the notice after 14 days. As per the new IR code, the 14 days now extended to 60 days. 60 days they should not go for any strike after submitting the strike notice, and within 14 days of the submitting the notice, within 14 days they should not supposed to go. If they go for that, it is inviting for the disciplinary actions against them. So 14 days now increased to 60 days strike.
Okay, sir. Okay, sir. Thank you for your valuable time, sir. Question and section over, sir.
Thank you, Dharani, for handling this section.
Thank you so much.
Now, I am glad to invite our guest faculty, Dr. R. Selvamani, Department of Social Bharat University, to deliver the vote of thanks.
Thank you, Mr. Pugarjadi. Warm good afternoon to one and all. I'm happy to deliver vote of thanks this wonderful occasions. On behalf of Department of Social Work, I should be like to thank our today chief guest, Mr. Vijaya Kumar, Head Human Research and ICTC and PDS Division Unit and Coimbatore. His excellent speech He is sharing and knowledge and experience in the industrial relations practice. He is cover and overall the trade union and standing under notice of change and voluntary reference to distribute and mechanism system of industrial distribution and stake and lockout and layoff and retrenchment and closes and also on the offense and penalty in the industrial relations code and 2020. I hope it's very useful for all the participation in the features. It's a very enrichable speech. Thank you, sir. I thank and participation who has paid their attention in the learning and discussion and interaction during the chat sections. The HR specialist is one of the most quote in from the right person in the right job. And the same concern, our program coordinator directors has decided the right time and right topics in scenario because in the pandemic situation and industrial revolution is totally different to change. That's why I've selected and most variable topic of industrial relations practice in Indian current scenario. So I my heartfelt thank to workshop director and head of the department, Professor Maglesan sir, for the selecting and wonderful topics. And I thank and our senior faculty, Dr. P. Ilango, and Associate Professor G.O. Jerida Nanjo ma'am, and Assistant Professor Dr. D. Nirmala ma'am, and Dr. N. Rajavik sir. And our guest faculty, Dr. M. Suresh Kumar sir, Dr. R. Karthikeya sir. I thank the workshop coordinators, Mr. Balaji, Ms. Dharani, Ms. Jayapriya, Lakshmi Sri, and Mr. Pagaljodi, Ms. Hansia, and Ms. Salini to support and play a great role in the organizing this workshop and wonderfully manner. Thank you to all. And the same and special thanks to our department research scholars and MSW members of the department for active participation. Once again, thank you to all the participation. Thank you. Over to Mr. Pagaljodi.
Thank you, sir. Thank you all. Our next session will be begin at 4 o'clock. Kindly join us.
Thank you. Thank you so much. Thank you.
Dear participants, the attendance form link will be posted in Zoom chat box and YouTube chat box and Telegram group also. Kindly give your attendance for this section. Thank you, sir.
Okay,
Thank you, sir.
Thank you so much. With that, I'm leaving now.
Thank you, sir. Sure.